Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related and pro se related as well. So today we're going to talk about some interesting legal terms. So today's topic is pro se foreclosure terms explained, and the Bible verse of the day is Proverbs 28:5. Evil men understand not judgment, but they that seek the Lord understand all things. Okay, so keep in mind that Jesus will help you with your foreclosure if you pray to him and ask him for help. I promise you, he will never let you down. Okay, so today we're going to talk about legal terms and phrases that often appear in motions, court orders, and legal briefs. Many homeowners and pro se litigants become discouraged when they encounter unfamiliar legal language. Words like prima facie, res judicata, standing, and summary judgment can make the legal system seem confusing and inaccessible. But Proverbs 28:5 reminds us that those who seek the Lord gain understanding and discernment. True justice is not merely about technical compliance with rules. It is about fairness, truth, and righteousness. By learning the language of the courts, we become better equipped to recognize what is being argued, what is being decided, and whether justice is truly being served. Knowledge removes fear, understanding removes confusion, and wisdom helps us separate truth from error. So let's begin. Section 1 is going to be Latin terms. So let's go through this list so you guys get a better idea of them, because you'll come across them. Res judicata means that the matter has already been decided. Maybe you had a previous complaint and it was dismissed and they want to relitigate again. So you don't get a second bite of the apple. That's what res judicata means. Collateral estoppel means an issue already decided cannot be relitigated. Prima facie means enough evidence to establish a claim on its face. Inter alia, among other things. De novo, starting from scratch, no difference from prior decision. Sua sponte, the judge does something on their own initiative. In camera, judge reviews evidence privately. Ex parte, communication with the court without the other side present. Pro se, of course, means representing yourself. Per curiam means opinion issued by the court rather than a specific judge. Ab initio means it's void from the beginning, or void ab initio. Bona fide means in good faith, genuine. Cavit emptor means let the buyer beware. Consensus ad litem means meeting of the minds. Pro bono, for the public good, free legal work. Quid pro quo means a mutual exchange. And an amicus curiae means friend of the court. Section 2, motion practice. These are terms you're going to hear if you're fighting them. So motion to dismiss, even if everything you say is true, you still lose. That's what they say anyways. A summary judgment. There is no disputed facts for a jury to decide. A reply brief. Defendant gets the last written word. A surreply means extra reply allowed only with permission. Memorandum of law is the legal argument supporting a motion. An affidavit is a sworn statement before a notary. A declaration is a written statement under the penalty of perjury. A certiorari, order for a lower court to send records. A mandamus is a writ commanding a public duty. Section 3, jurisdiction terms. Subject matter jurisdiction. Court's power to hear the type of case. Personal jurisdiction is court's power over the parties. Venue is proper geographic location for the lawsuit. Standing, the right to bring the claim. Ripeness means too early. Mootness means too late. Section 4, foreclosure specific terms. These you're going to come across. Holder means person, entity possessing the note. Holder in due course means a special protected holder under the UCC. Assignment is transfer of rights. Endorsement is signature transferring the note. And allonge is an extra page attached to the note, and it must be attached. It cannot just be free-floating. Servicer collects payments. A trustee acts on behalf of a trust. A beneficiary is the person or entity benefiting from the trust. Acceleration means calling the entire loan due. Default means failure to comply with the loan terms. Section 5 are your trial terms. These are you're going to hear if you make it to trial. Burden of proof, obligation to prove your case. That's what the plaintiff has. Preponderance of evidence means more likely than not. Clear and convincing evidence is a higher standard. Hearsay means out-of-court statement offering for the truth. Foundation, evidence required before admitting a document. Authentication, proving a document is what you claim it is. Section 6, common federal terms. Rooker-Feldman, federal courts generally cannot act as appellate courts over state court judgments. Younger abstention, federal courts may stay out of ongoing state proceedings. Claim preclusion, another name for res judicata, which means previously ruled on. Issue preclusion, another name for collateral estoppel. Rule 12b-6 means failure to state a claim. Rule 56 is a summary judgment. Rule 15 are amended pleadings. Section 7, words judges use all the time. Construed means interpreted. Alleges mean claims without proving. Contends means argues. Aver means states as true. Material fact, important fact affecting outcome. Meritus means high legal merit. Frivolous means not reasonably supported by law or facts. Dispositive means decides the case. Remand means send back to the lower court. Vacate means cancel prior order. Affirm means uphold lower court. Reverse means overturn lower court. So as we have seen today, the law is filled with terms and phrases that can seem confusing at first. Words like prima facie, res judicata, standing, and summary judgment may sound intimidating, but once you understand what they mean, court filings become much easier to read and understand. Knowledge is one of the most powerful tools a pro se litigant can possess. The more familiar you become with legal terminology, the better prepared you will be to recognize the issues in your case, respond to your opponent's arguments, and present your own position clearly and effectively. Proverbs 28:5 reminds us that those who seek the Lord understand justice fully, whereas evil men do not. True justice requires wisdom, discernment, and understanding. By taking the time to learn the language of the courts, you are equipping yourself to navigate the legal system with greater confidence and clarity. Thank you for joining me on Foreclosure Help 777. And if you found this presentation helpful, please like, subscribe, and share with others who may benefit from it. Until next time, keep learning, keep fighting, and never stop seeking the truth. And if you guys want to find a more comprehensive list, they're under Wikipedia, list of Latin legal terms, which is interesting. As you can see here, Wikipedia has the complete list of everything that you didn't want to know about everything. And you can go through it alphabetically if you would like. But I think it's interesting that this information is here, and it's definitely worth looking into if you're fighting the banks, getting more equipped to fight them and win your case. Okay guys, thank you for joining me for this episode, and if you have any questions or comments, you can leave them below, or you can email me at foreclosurehelp777@gmail.com if you have a question about your case. I will try to help you answer that. And as always, everyone have a blessed day.